on. We're back on the record. During the break, we clarified something with the assistance of somebody else in government that we can go past 4 o'clock. So we will be proceeding past the hour of 4 o'clock unless somebody has some objection. Okay, hearing none, we'll go back on the record. Maybe we
Excuse me, in terms of witnesses, we had some witnesses up to council about it for tomorrow, figuring.
Well, we're out of, if we're out of witnesses, we're out of witnesses. We just didn't want to stop at 4 o'clock with this witness. We want to try to get through this witness at least. And if there's another, yeah, if there's another witness available, we'll take them. The original notice was to end at 4 because of this.
No.
No, more the availability of certain staff. But we've resolved that now that so we can go past 4 o'clock. So, so you may redirect.
With respect, you have Exhibit 6, the draft purchase agreements. Mr. Shearer is asking you some questions about IVSC technology and indemnification. All that?
Yes.
Is IVSC technology part of the release and settlement agreement that you have in front of you as Exhibit 6?
No.
And does the agreement pertain to IVC patents and licenses and releases to their patents and not IVSC technology? Nothing so.
That open up any additional questions from you, Mr. Sherrill, administrator, or anybody? Questions of board members? Do you have any questions? Is it?
Yes.
Mr. Meyer? He's a little more organized.
I was hoping to collate my notes before tomorrow, but let's see if I can.
Oh, you were hoping we were quitting at 4.
I think this was answered, but I just wanted to clarify. You testified that you took some diligent action for the past, since the original notice, I think 2021. Did you challenge the patent claim?
We did not.
I'm going to ask a basic question. Well,
Since you participate in vision, you can ask. me a
okay,
question.
all right. So based on the settlement agreement includes the pass-through fee. Would these, so you've agreed that Captain owes IVS 50 cents per ride. You're proposing that that's what's owed to them, correct?
We have taken the measures to calculate what we feel at this stage is a reasonable settlement proposal between the parties in final draft. And also through the rate change structure of proposing through a certificated applicant, we felt that that was a reasonable number.
Okay, but the rate change is you're requesting of the board to approve the rate change, but out of that context, you're proposing that Captain owes 50 cents per ride. And I guess my question is, if Captain was paying that and the fee was not being requested to be approved by the board, would that 50 cents still apply, which includes the 12.5 cents, or might you feel that 37.5 or some other figure would be more appropriate?
What I can tell you is that the original proposal of a fee, of a license royalty fee for the umbrella patent, non-exclusive umbrella patent, was upwards of $1.20 to $1.30 initially presented. So the efforts that we took, and at that time, we didn't know if IVSC at that stage was discussing this with either any other carrier or operator or technology company. We were only caring about our company and our clients and the impact that this would have. And through the efforts, most specifically of Mr. Bell, calculating and explaining, being somebody as an operator and a part of our board who's been through a lot of rate changes, has been a lot of through, just a lot with the regulation of the transportation market of not only Southern Nevada, but Nevada, was able to get that down to what we felt was a reasonable 2.5% of the current average fare of taxi cabs.
Okay, so then potentially what's owed is $1.20, $1.30. And so I guess my question would be, is Captain kicking in 70 cents, or are you saying that this was the rate that was negotiated to both parties' satisfaction?
My answer is that the original proposal from the patent holder to Captain, as to my knowledge, the only technology company that IVSC had come to, at least in Southern Nevada, was $1.20 to $1.30. And that basis, which I asked at the time why, was based upon a look at other reasonable referrals of patent enforcement and infringement license fees in other markets, not specific to taxi cabs or for hire vehicles, but specific to other reasonable references that they made.
Okay, so theoretically, we could, from the board's perspective, we could look at the 37.5 cents as being what both parties are agreeable to, and the 12.5 cents is something totally different that the applicant has included in the rate increase, I guess.
Correct. So the negotiation of the settlement agreement, which has been submitted on behalf in final draft form, not fully binding or executed in current state. That is the evolvement of negotiation on the 50 cents to be broken down to 37.5 cents, which would be collected as a single pass-through extra if approved, and then reconciled in a manner of 37.5 cents being remitted to patent holder for the efforts of the patent ownership and license fee, and the 12.5 cents being potentially remitted to all technology providers, not exclusive to Cal.
Well, but your interest is in 37.5 cents. Mr. Balaban's interest is in the other 12.5 cents.
The only interest I have in the 37.5 cents, let me restate, I have no economic interest in the 37.5 cents. I only have interest in protecting my company and my clients.
I'm not exactly seeing how those two things are exclusive, but I guess I'll ask this: why isn't Captain responsible for the 37.5 cents?
We felt, given all the circumstances in research and review, and also in discussing this with our clients and understanding the economic impact, given the current margins of the business between technology vendors and their certificated carriers in the taxi industry here, that the fee would effectively put us underwater, given the current amount of trips that are facilitated between the parties.
Okay, so that's where I'm going next. So can you describe for the board the impact that Captain having to come out of pocket for 37.5 cents would have to you and potentially your clients?
Sure. So I can answer specific to Captain, because that's the only economic impact that I truly know. The other, I base off public information, statistics that are generated through your agency. I can tell you, we would not be able to sustain that dollar figure per trip. It doesn't fit into our ability through our margin profile today with our operators under MSA to bear that cost.
One other question. The proposed settlement agreement between you and the patent holder doesn't include an alternative arrangement in the event that the board denies fee increase.
That's not.
So was that not considered?
It was discussed in an effort to have what I would call Plan B, a Plan C, and a Plan D in business sense. At the current time and up to current state, the patent holder did not want to entertain that discussion.
Okay. Thank you.
Mr. Meyer, Kaplan is not a certificated carrier,
Captain Technologies is not.
but the way the rate request is structured, it will be actually directly receiving a portion of a rate charged to the ridership, riding the 12.5 cents.
My understanding in being a part of enough rate change situations over the years, and frankly, being the manager of a company that would then go tell my engineering and development staff that you are now appointed to evolve metering and fare and tariff and reconciliation and remittance process, which I've done many a times. My understanding is that if this were to be approved, that we would do no different, that we would add a extra to the tariff schedule on all of the DT5 meters that we control and manage and market under contract. And then we would collect that on behalf of whomever the agency deems appropriate or legally structured to collect that. In this proposal, 50 cents as a one-time fee per trip would be collected. It would be treasury managed, and it would be remitted to patent holder in the form of 37.5 cents per trip and 12.5 cents to technology provider of company.
But I think it's your testimony that substantially all of the certificated carriers use Kaplan.
Currently, I may be off by a few here, but approximately 2,000 to 2,100 of the certificated vehicles have Captain Technology running.
So 22 of 3,300.
Approximately. Over half.
You may tell me you're not the right person on this. The 37.5 cent allocation to IVSC says that it is, quote, for patent royalties and defense, end quote. Do you know what is meant by and defense?
I do not.
Okay. So at this point, the draft non-exclusive patent license agreement is not a valid, binding, and effective agreement between anybody, right? It's just a draft proposal.
Draft, given current state of negotiations and frankly, the evolution of the process that we're currently in as well.
And it does not include any indemnity of by IVSC of Captain, does it? For should IVSC be found to have violated somebody else's patent.
Correct.
And in it, IVSC disclaims any warranty for infringement, correct? Likewise, the release and settlement agreement is not currently a valid, binding, and effective agreement, right?
Correct.
And it's subject, as I read it, to a condition precedent that we approve the application as filed.
Correct. That's why patent holder has requested multiple times to keep in draft form, to not continue to spend time, legal dollars, negotiating any further until decision of agency is Taxicab Authority Board is deemed understood.
So so this is a hypothetical, the board grants something less than what is requested in the application, none of these agreements would be anything we would rely on because there'd be something else negotiated.
Hypothetically, if I may, can I give my hypothetical opinion
You can
of
give
what
me,
would transpire?
I'm asking for what happened.
Being one that's been a ping pong ball in this situation, hypothetically, my opinion to that question would be that that the parties would find a fair and reasonable negotiation amount of this current construct of a release and settlement agreement, as well as provide the full market and umbrella non-exclusive royalty patent licenses that clearly protects the technology companies in market today, as well as the certificated operators in past and future protection against the patents.
And as I really, I think,
That is just my hypothetical.
I understand. Ms. Guerra asked something along this line, but didn't take it all the way as I wanted to understand it. This reference to a master services agreement and to some other agreements, they don't exist today. So we don't know what they say, right?
The efforts of the master services agreement was to better specify if the patent holder did not want to include more broad and effectively more broad indemnification language on technology company and its clients. So the master services agreement was and has been an effort to get the patent holder to have a clear and concise business agreement with the technology company that then would tail to the technology vendors indemnification agreements of their current master services agreements with their clients. But that agreement is not in place. The negotiations of that have been albeit verbal.
Is my reading of the proposed release and settlement incorrect when I conclude that it basically provides for Captain to be the technology provider by name? Does not contain language in it that has a blank for who the technology provider is. It says Captain.
Correct. In the current form, it does. The effort of the.
That's my question.
Sure.
Captain entered a service agreement with taxi management February of 2024.
That was a renewed master services agreement, correct?
Did you disclose at that time to taxi management that you were in breach of your warranty of non-infringement?
Can you restate the date of the tax manager? renewal?
February 2024.
No, we did not state anything in reference to the IBSC situation. We were made aware of the newly issued patents and their detail in and around August of 2024, after the renewal was signed.
If I understand your testimony in response to Member Decker, you are testifying that your pre-tax operating profit from the licenses you give to certificated carriers is not sufficient for you to pay the 37.5.
Right.
The through rate was negotiated between Captain and IVSC, correct?
Correct.
I'm giving deference to your testimony that you proceeded because you thought it was in the best interest of your customers, and that was what you were doing. But isn't Captain, I don't understand why Captain's not the primary beneficiary here. And let me tell you why I'm saying that. One, it is Captain who apparently believes it cannot perform its obligations to indemnify the carriers if a patent case was brought. You have your contracts indemnify the carriers against just this type of a case.
Right.
And by obtaining the rate, you basically pass that indemnity obligation off to ratepayers. You'll be relieved of that indemnity obligation, correct?
Specific to this patent holder situation, yes.
And on top of that, given your prominence in serving the carriers, you're also going to receive 25% of this pass as a technology.
Right.
So you're a major beneficiary of that.
In turn, yes.
Well, you're a beneficiary, Mr. Meyer, if I understand it, because you don't have to go back to the carriers and raise prices, right?
Right.
You're getting the 12.5 cents in lieu of going to them and saying prices have to go up. But given your earlier testimony that you've been around this rodeo, if your prices increased to the carriers, then in our annual review of rates, we would see that additional cost of service and determine whether it was just and reasonable to give them the rate increase, correct?
Absolutely correct.
So we're bypassing that whole process. Yes or no?
Yes.
Yeah.
No.
So along those lines, I mean, it's been alleged by the patent holder that you, for approximately 4 years, didn't stop using the systems which infringed. You didn't provide them an accounting of your profits. You didn't hand those profits over to them. You didn't pay their attorney's fees and costs regarding the infringement. So theoretically, there's a penalty to be paid for 4 years of the use of what they allege is their product, I guess you might say. So you're asking for future writers to pay 37.5 cents to satisfy any future licensing agreement in addition to settling 4 years of what you might severely call, I don't want to call it misconduct, but maybe they allege that it is. Is there any financial penalty or any penalty of any type to Captain based on this current arrangement?
Well, let me clarify. This is something I learned this process as it pertains to conventional patent infringement, in turn creating patent licensing royalties against infringers. Again, not specific to the taxicab industry. Damages can go back 6 years, not 4, or time of information understanding, as I would call it, which is all I deem the 2021 letter to be, given what I stated and answered earlier. Now to answer the question at hand, no, Captain is not to have any other penalty or anything past the goal and efforts of what is in draft form in the settlement and release is for Captain and its certificated operators under contract and the rest of the certificated market to not have any penalty for what the patent holder deems there has been infringement in the market for many of years.
In your testimony, you earlier today, you cited event fees as an example or precedent for what how reasonable the 2.5% of a $20 cab ride was. Do you remember that testimony? Yes. When you're saying event fees, are you saying the surcharges that the board has approved for like electronic daisy chain? Is that what you're saying by event fees?
Yes. When there's like a specific amount fee that's added to a high, what I would call a high volume event calendar.
And did you sit through any of the proceedings where those surcharges were adopted?
Yes.
Wouldn't you agree with me, Mr. Meyer, that the public policy of the board in doing so had nothing to do with IP rights or anything else? They were to incent drivers to show up to work for events that they might not want. Is that correct?
Correct.
Please edify me on how that is any way, shape, or form. If all you're saying is that the amount
It was more an economic reference, not any reasonableness against the specificity of why.
So you would agree with me that they're really apples and oranges.
Correct.
Correct me if I misunderstood. I heard the $20, $50 original ask of IVSC. But my interpretation of the record is that the number was 60 cents, dime, 50 cents. That was the negotiations.
Well,
That's at least what's in the record.
yeah, well, remember the meeting, this was brought forth vigorously last August. And that's what, just a quick timeline, that's what prompted myself to reach back out to expert counsel, which is still Mr. Urio and was back in 21. Mr. Urio quickly did a claims analysis on the newly issued 2021 to 2024. And that's what caused an urgent calling of meeting to the clients, which then caused an urgent, what are we going to do to get aligned as a solution, which caused, we have to go sit down with the patent holder and understand what they first think is reasonable against this marketplace. And the original, I won't even say pre-2025 dollar figure was in the 120 to 130. We were then able to get them to come down.
if hypothetically were to approve some relief on the application, is this forever? What's the duration?
To my current knowledge, only speaking to the patent validity or patent tenure is a better business word. I believe the lifespan on the patents that are currently in infringement assessment is up to 10 years. But that, I don't know what type of bearing, Chairman, that has on what the decision ruling would be on the regulatory board. And I will go one step further and tell you that based upon 1 and 2, 3 would be our MSAs and our agreements with our client would reflect the amenability of 1 and 2.
1 and 2 being,
The tenure of the issued
Oh,
patents,
okay.
and then 2 being the decision timeline of the board's discretion.
what other options did Captain evaluate? We've been told that what's before us is the only viable alternative, the only path forward. What other alternative was about?
3.
Okay.
1 was I took this to my board to, along with the analysis of Carr and Farrell, LP, who is a very credible IP counsel in the United States, and specifically Mr. Urio, I've worked with for over 4 years. I'm sorry, over 8 years, because we've dealt with multiple IP claims over our tenure. That's sometimes a good thing, means you're doing something right. And given the analysis and claims work that had been done, extremely thorough work on behalf of Mr. Urio, that in conjunction with the economic understanding of what it would take to fight this individually on behalf of our clients. This was before going to our operating clients, was a burden that we at the time didn't feel we could take on. Whether we felt as though that we had an ability to invalidate, that was irrelevant in assessment at the time.
Was not irrelevant?
Was not, it was more economic than it was the time frame and the amount to get a court to decide yes or no. So that was number 1, and that was the first proactive solution that I went down. The second was I met with a few of my certificated clients and informed them of the same information that I informed my board, and frankly asked their advice. What can we do? What should we do? What do you think is an amenable next step here? Knowing that I have indemnification clauses, being very open with them about the structure of the business that we've had with them. And I will say openly, the business relationship that I've had with most of my clients here has been very open in an effort to have each other understand what, to keep us both around, frankly. When you work with clients the way I do in this industry, a small industry, everybody, for the most part, knows everybody. Most of the vendors know each other. And the reality is most of us try to do the same things to build their client base. Las Vegas has been one that Captain has been able to really go deep and wide in for a long time. So that conversation was not a hard conversation for me to have with my clients. And it was a sticker shock conversation, to use, a business term. And that's what, led to the decision of, do we think there's a fair and reasonable fee that could be imposed, or a better negotiation with patent holder at the time? And, those conversations took about a month. That wasn't a one-time conversation. The third was reaching out to a few industry competitors, whether they operate here or not, and asking them to do the same work I've done as a reference point. I've been in this industry almost 20 years. I know a lot of the other technology companies. I know a lot of their decision makers, and I've reached out to a few, asking them if they could frankly reference the work that my expert counsel had done, not as an operator, but as a technology vendor in this space. That was the third effort I took.
Guys.
Can I ask 3 more? And then we can-
Oh,
go ahead.
what was the result of that?
Which one?
The latter.
Number 3, when you reached out to the other technology providers, what was the result?
At the time, they didn't want to bear any cost, given that the patent holder had only come to me thus far. So then I used the term quote unquote, so I guess I'm the guinea pig.
So I will assume from that you did not evaluate what the cost to the certificated carriers would be of transitioning from a non-infringing technology to a non-infringing technology. Didn't evaluate what that.
Yeah, we felt through counsel's advice based on experience, not specific to the taxi cab industry, that it would be anywhere from 5 to 8 million for us to I believe it's 3 to 7 million, that specific one, to and somewhere between 3 to 5 years for that process to take place to determine a result in action.
And so if you didn't consider that, you also didn't consider how that might be presented to the board as an alternative way of solving this problem through a rate.
Correct.
I also assume you did not look at insurance policies for captain's breach of its indemnity or for any liability that the carriers would have.
We did do that proactively right away, and it actually came through the suggestion of one of our certificated carriers.
And what was the cost of that?
Well, specifically, the carrier would not insure patent infringement. And my counsel at least explained to me that that is normal in this course of patent infringement.
Your counsel informed you that there are not insurance policies for infringement?
Not specific to this type of infringement.
And so you didn't also, I assume, discuss the carriers and captain litigating this out and to the board and asking for the board to give great relief to eventually fund your litigation.
I could not get full alignment on that.
Alignment from the carrier.
So in that instance, you tendered a claim to the carrier, general liability, errors and omissions, whatever, and they denied the claim.
I didn't go through full claim, merely number one, review of current policy. Number two, discussion with councils around, could this be an additional waiver policy? Can we go do this? And then we did not submit the claim.
Okay. Why didn't you submit the claim?
We were advised that this would not be covered.
So you've said that a couple of times throughout the hearing today, this advice of counsel, that's your counsel here today.
Correct. Mr. Uri is our IP and patent counsel. We do have various other counsels that were made privy to this matter. They're not representing Captain today.
But in your testimony here today, a couple of times that you took and did not take certain actions, that was on advice of counsel.
Correct.
So look at Peacock letter real quick and the
Sure.
attachment that's with it.
Okay.
It's exhibit 18 for purposes of the record.
I may not have the full, your attachment,
It's
meaning the full patent, right? At the time, 852.
Yep. And I think you have it, don't you?
Have it.
Where's the page? No, we're gonna get you out of here. I'm gonna be quick. So this is the September 20th, 2021 letter you got from Peacock Law, and it's, this is the demand on the patent infringement, right?
Correct.
Okay. So then in response to this, you didn't make an insurance claim.
We did not.
Okay. So then if you look at the US patent form, it says the date of the patent was for May 19th, 2015. Did I
Correct.
read that correctly?
Correct.
Okay. And that's your understanding as to when the 852 patent was issued?
That is my understanding.
So then in your testimony, which is exhibit 21, yes, yours written testimony.
Yep.
The paragraph, let's talk about 8 first. Paragraph 8 talks about the past damages that could be recovered against Clark County certificate holders was approximately $40 million. Did I read that correctly?
Correct.
How was that calculated?
That was calculated, to my knowledge, based upon a percentage royalty fee of trips going back 6 years.
Okay, so, and going back to this, the letter, they had at least 6 years because the patent was issued in May of 2015.
Correct. I just, if I could, one section up, section 7 in my testimony.
Yep.
You'll see there are newly issued patents.
Yep.
Outside of 852. What to me, in turn, my company and my clients became extremely relevant was not 852 issued in 2015, but it's actually the subsequent issued patents in the interim.
Okay, and what, as you sit here today, do you know what years those patents were issued? And I'm sure we'll have testimony about that later on down the road, but we're going to need some direction.
Yeah, the most important one was actually the most recent issued patent, which I believe was issued in the last 18 months.
Okay, and that's helpful. But in going back to paragraph 8, though, do you know, did they calculate the number of rides? Did they look at that and say, okay, we're going to do X amount? How did they calculate the 40 million in damage?
Yeah, we did have a meeting on this, and I remember that meeting. And it was early when they were talking about the total impact of what they felt this infringement of total taxi market was, both certificated carriers and vendors, i.e. total trips. So it was a 6-year look back, to my understanding, of total amount of trips plus a percentage of average fare against those total number of trips.
So the option number 3 that you talked about, 3 different alternatives, whatever, and option number 3, did you talk to other providers of technology like yourself in other jurisdictions?
Yes.
Have any of them received any type of cease and desist demand letter from the IP holder?
To my knowledge, no.
Okay. Is it your understanding as you sit here today that it applies to those other providers?
It is.
And why is that? What's your understanding?
It's my general experience and understanding of being a technology provider in the regulated taxicab industry.
Okay. I guess we'll get some of that from other people though. You have, or Captain has a contract with Desert, correct?
Correct.
They had a contract back in 2021.
Correct.
And in that contract, I think you've already testified to this, there's indemnity between you and Desert.
Correct.
Okay. Has that contract been produced in this case?
Specifically the Desert Cab MSA? To my knowledge, I don't believe so.
Has any of the contracts between Captain and any of the license holders been produced in the case?
Taxi management, or also known in market as
Okay.
Yellow Checker Starring Companies, yes.
And that is exhibit 14. Thank you. Yep. Okay, so looking at exhibit 14, that's the contract, it appears master software license and service agreement between Captain and Taxi Management.
Correct.
Okay. And then if we look at paragraph,
Commissioner Graff, I don't specifically have it in front of me. I'm pretty well knowledged on it, but
can we give him a copy? Okay.
thank you.
Well, let's walk through it.
Sure.
At the bottom of page 6, it has the term and termination.
Yep.
So this contract was entered into February 28th of 2024.
Correct.
So this contract would expire in 2027, and it's probably got some extensions.
It would expire then. And yes, it has some clauses for renewal terms.
Okay. If you look at the bottom of page 9, and that's the section 8.1 that you were previously testifying about
Correct.
as to the indemnity, right?
Correct.
So you've read this a couple of different times, right?
Too many.
All right. So what does this provision provide?
This provides an indemnification to my client for the rights of what we provide to them from a software and licensing and technology perspective, as well as to hold this client harmless from and against all third-party claims.
Like IVSC, IP.
Correct.
Okay. So you talked about it a couple of different times, but I wanted to just tell me, how did you come to, and if it was negotiated between the parties, that's fine too. If it's kind of like what Chairman said, is that they started at 130, went to 10 cents, went up to some number and then got to 50 cents, that's fine too. But was there any effort to calculate the 50 cents?
Yes, the 50 cents was calculated down to a lower percentage of where the original 40 million calculation of a percentage via trip was calculated. So I believe they were, meaning the patent holder, initially in the 6 to 9% realm of a trip. And frankly, through Mr. Bell negotiating and trying to get it down as far as possible, got landed on 2.5 cents in the current form of the application proposal and settlement draft agreement.
2.5%. I knew what you meant.
Versus, yeah.
You said cents.
I'm sorry,
That's
yeah,
all.
6 to 9.
But you meant 2.5%.
I did mean 2.5%.
Okay. Did you guys employ anybody to come in and crunch any numbers or anything like that in determining that number?
We did not hire anyone specifically from a macroeconomy perspective. What we did, we looked at the total amount of trips that the taxi industry of Las Vegas had done post-COVID. We also looked at, as I previously mentioned, we looked at other reference points of license infringement cases from 2 different councils that we had on staff. One was Carr and Farrell, the other was Harris Beach Murtha.
One was Colin Farrell and what?
Firm
Harris
number 1
Beach.
was Carr and Farrell. The second firm that we engaged was Harris Beach.
And then go to exhibit 6 real quick, which is the confidential release
Yep.
and settlement agreement.
And then there was a couple of different people asked you questions about it, so I just want to make sure the record's clear. You'd agree with me, though, that the parties to the confidential release is Captain Technologies is one party,
Correct,
IVSC IP is another party,
correct.
and then it's got a to be determined
On Exhibit A,
as to
the
any
operators.
law operators, okay. And I think you called them the taxicab operators at some point in time, and that's who you're referring to.
The certificate carriers.
And on this document, there's page full of signatures. Blank signatures.
Correct. Yeah, Exhibit A is filled out. Signed.
Chairman asked you some questions about whether or not there was any term to this agreement. That,
Correct.
was there any discussions between or amongst the parties that are listed in this agreement that it had a specific term or expiration?
There was not specifically and the reasoning being, we didn't want to frankly short side ourselves on term. In this agreement, we wanted to go with what would be the most amount of protection possible. And we haven't deemed that appropriate yet. Many years as possible as potential patents would have validity on the market.
Council asked you some questions about a claim chart on the Peacock letter. Remember that? Okay. Do you know what a claim chart is?
I know what it stands for now, but I can't tell you what it means if I was to look at one.
Well, what does it stand for?
A claims analysis of the patent and its legitimacy of detail.
How often it's been used by other parties, presumably by you or by anybody that you've licensed the product to? Is that yes?
Yes.
All right, you gotta say yes. Not being rude. Okay, I don't think I have anything else.
I have something.
Yep.
So you've got a hold harmless agreement with your clients, got wrong insurance, apparently, got an infringement claim. You've done what I would describe as overstepping your authority in negotiating a potential board decision into a settlement agreement. Testified that Captain can't absorb 37.5 cents. You're in a dire position, would you say?
I'm in a precarious position.
Okay.
And not knowing what the ruling will be. And also back when we decided to ask Mr. Balaban and other operators to be the applicant. It's also when I found out I couldn't be the applicant. I should have known that after all these years. The timing and the ability to present this in the way that we have gone through it, at least today, has always had us in a precarious situation. But at the same time, the largest concern has always been what would happen if the patent holder decided to enforce this against everyone all at once.
Well, you said Captain can't absorb the settlement costs. That puts you in a dire position. You theoretically, I mean, I think I've heard you testify or read it. You, or at least the LOA believes that you won't continue to exist without a settlement with the patent holder, some kind of settlement.
I can't answer that at this point. There's too many other various calculations and situations and decisions given the portfolio that would have to be done for me to be able to answer that correctly.
Okay, well, that makes more sense because I think negotiating in a potential board decision, a settlement agreement is a very bold move. I can't wrap my head around why you need 37.5 cents from the public through a decision from the board. You would include the 12.5 cents additional or exclusive of other technology companies for yourself, which leads the public to pay for Captain's benefit ultimately, not only any infringement costs or licensing costs, but also for future operations. So if you're not in a dire situation, that makes a little bit more sense. But I still think it's a large ask for a company that I was led, or it seems we were being led to believe was in a dire position, an existential threat. If that's not the case, then I get it. But so let me just ask this: is Captain's solvency a problem outside of this infringement case, or is this just does the 12.5 cents speak for itself? You're looking for the public to pay for Captain's tech.
We are
Before you answer that question, let me clarify. Do you need the 12.5 cents? Isn't that what you're asking?
Yeah.
Can I specify, please, outside of the 37.5 cents, because that's what makes it be able to answer that.
Well, hang on, because I thought we just said we weren't in a dire position. So I'm going to assume when you say that you don't need the 37.5 cents to survive, you're not in that kind of dire position, right? Wasn't that your answer?
My answer is if we never had this case to begin with, I'd be fine. That's the best way for me to answer this. This case has arisen, I've never dealt with a case like this in my career in this industry in multiple markets. So this case has arisen multiple different issues. This question that's being asked of me now being a solvency one, yes, is a precarious and dire situation given the amount that the patent holder wants from this. So that's the only reason that we're in a dire situation economically, is because there's a patent holder that we have multiple choices to respond. We can fight this and spend upwards of $5 million or more in multiple years of court cases to try to fight, win or lose, not knowing the outcome. The second, which I've put on record, is that Captain independently, now on record with other operators and technology competitors hearing it, can't pay that out of its margin per trip in current state. So,
Sorry, did you say the carriers can pay it?
no, I just, meaning I'm in the room with the industry.
Well, I want to make clear that this application is asking the public to pay for it.
No, I understand.
Okay, I just want to make that clear that it's not Captain that's going to pay for it. It's not the carriers that are going to pay for it. You're asking for us to pass through a cost to the public to pay for it.
Correct.
So if I'm just unclear as to whether how necessary this is. If you're not in a dire situation, if we don't, there's a couple levels. You're asking for 37.5 cents to pay for licensing, potentially anything that's happened over the past 4 years, and in perpetuity into the future, the public will be paying for Captain's licensing of the patent holder software. You're also asking for 12.5 cents for the public to pay through the carriers to Captain for exclusive tech. Theoretically, someone at Captain or at the LOA or attorney was going to know that the other tech companies were going to pose that, because they're not benefiting from the 12.5 cents. They may submit their own pass-through cost for their software, that kind of thing. So I'm just wondering, at what level is Captain? Do you need the 37.5 cents because you're in a dire situation? Do you need the whole 50 cents because you're in a dire situation? Are you just asking for the public to pay for your software? Because somewhere in that range is where you are, and I'm not exactly sure.
Yeah, I'm sorry, Commissioner Decker. I'm struggling. If I could clarify my why, maybe that will help. We have looked at this unconventional situation in which we've brought this to Taxicab Authority Board through an applicant client. Our largest reference point dates back some time in this market, but it's the $3 credit card surcharge, in which the operators did not want to bear the processing fee, which effectively is a licensing fee, just much more than 50 cents, a lot more. And it's still in current form. I will answer the way I did earlier, which is we don't need today any part of it to be a stable business of the pass-through. In some aspects, I'll go back to what Chairman Reeser and I were kind of doing Q&A about 30 minutes ago. I believe the 12.5 cents is a justified technology fee for all of the vendors in this industry. We are facing and have faced all of us challenging times over the last 8 years with market competition. And while it may seem initially as sticker shock that how could you as a vendor increase the passenger fee when other larger publicly traded companies and platforms that are not governed the same way any of us in this room are lesser than you. I don't agree with that because there's a much deeper understanding to the long tail. And that long tail, first and foremost, includes passenger information security, which is a big issue in today's technology platforms, one of which we spend ample dollars on proactively every year for our clients. The way in which we are looking at the metering systems that we have, Captain being a pioneer in being the first truly integrated hard metering, secure soft meter, which is weird to say it that way, but it's true. And that unit has spoken for itself in this market and delivered ample and credible information from a reporting perspective to the agency that I believe has been used broadly to make sound decisions on rates. I frankly don't want to see that change. I want to see our ability to continue to involve AI, to continue to provide other payment methods that are applicable and useful and wanted by global travelers to this market, which we are in, frankly, maybe outside of New York City, the second most globally traveled city. And when you have thousands of regulated units that you're responsible for on behalf of your clients, it's important and it's costly. Engineering costs post-COVID have gone up 32%. And I believe, one of the best, if not the best, engineering team here. It's not the biggest team in the world, but it's a very important and industry knowledgeable team. And I need to continue to retain them and pay them. So, that for me is the justification around the 12.5 cents. Whether that this is the right forum to be presenting that in, that's your decision. And if it's not the right forum, and today and this week is not deemed the right forum, I plan on presenting it in the future, and I plan on being around. So, I felt as though that should be broadened to all technology providers because I appreciate and welcome the competition. I think it's healthy for all of us here in this room, and whoever's not in this room, I think it's healthy for them too. We need to continue to raise our standards, but we can't do it off pennies and nickels. We have to figure out a way to, invest heavily into the technology for the future. It's unfortunate we're dealing with this unconventional situation. I understand that. But again, my final statements are in and around, I felt the best plan of action prudently and proactively was to bring it to the commission this way.
Thank you.
So following up on that, following up on Commissioner Member Decker's question. Because you're involved with the industry, you understand the carriers come to us and ask for rate increases. They had a general rate increase 18 months ago. And the cost of your contract, what they pay you, is one of the inputs to us determining what rate increase they should get. You understand that?
I do.
Fundamentally. Why, if we were to approve the 12.5 cents, why wouldn't we decrease some other rate that the carriers are asking us for, because they've told us they're paying you for the technology, and now you're asking us to pay for the technology. I just, from my standpoint, it's kind of you ought to raise their prices. That's an input, that's a cost of service. It flows into the rate case, as opposed to the technology provider now going outside. And I'm now talking about a public policy issue.
Yeah, no,
Does Ford Motor come to us and say, we want you to put a 75-cent charge on here for automobiles that we're selling to the rate, to the certificate carriers, or Hartford Insurance says, we want you to put into some direct charge to riders what the insurance cost is to the carrier. Why shouldn't that all flow into the carrier's book of accounts that we regulate, and upon which we determine whether they're earning a fair return on their invested capital, as we are required to do by law? I'm just, from a public policy standpoint, I just have to tell you, I'm troubled with 12.5% as being bad public policy.
12.5 cents. Correct.
Huh?
12.5 cents, a specific dollar.
I'm sorry, what did I say? Percent? I'm
Yep.
sorry, 12.5 cents. It's not the amount, it's the methodology. If
Understood.
you were to say to Mr. Balaban, I need 12.5 cents more under my contract for every taxi ride to provide you service, I'm pretty sure that Desert would file a rate case, or in the annual review would say, our cost for technology has gone up. We need rate relief for that. And we would look at through the book of accounts, we'd look at whether or not that was warranted, whether it was over earning, or was he getting a fair return on his capital? I'm just, help me with this public policy issue, because I'm stuck on it.
I'm going to try my best to help you.
Okay.
This is going to bring up our industry. But one of the Captain has done and built a lot for the Las Vegas taxi industry over the last decade plus. And certain functionalities and features bear a better marginal return from the operating agreement with its clients than others. I'll be more specific. Credit card processing. Due to the $3 passenger surcharge. So while metering regulation, metering efficiency, fleet management technology, tariff uptime and functionality for regulatory reporting, to me, as an independent business owner, is just as or more important to the efficiency of the operator, retention of drivers, training, all of the things that are deemed competitive in the landscape. The marginal profile lies in the credit card processing because of the passenger paying the $3. So when certain providers do not have that marginal profile, it becomes a big issue in their renewal negotiations with me and the operator. And frankly,
That being credit card.
Captain does not process all of the credit cards in the Taxicab contracts that we have in place. I've let it be known to those operators that is a big problem if we were to ever face an issue. And if I were them, I would say what they said to me. Well, we have alternative companies we can look at. That's fair game.
Thank you.
Thank you.
Your chief. It's 4:45. I'm not going to put another witness on. I don't even know if we have another witness. We will resume at We'll open at 9. We will not commence until 9:30 because of the public notice.
Hmm.
We will go beyond 4 o'clock because we've made that vision. Yes, council.
There was one question about information about the issue dates of all the patents.
It's in that one agreement I saw.
It's in,
Paragraph 1 through 5 on the first.
it's
page.
exhibit 19. It's a summary. So it has it all in. I just want to show that.
Chair and board, just as a house matter.
What?
I spoke with other counsel during break about stipulating to entering the depositions into evidence. So we could not have to go by witness to do those
Great.
evidence. So if there's, I'm assuming still no objections, move to admit all the depositions and evidence.
Is there any objection to all of the depositions being marked and put into evidence?
No, we had another caucus.
No objection.
No objection.
No objections? Okay, so we'll, Webb will have to attend to identifying those in a revised exhibit. Okay. Great. Anything else to come before us this evening? Okay, very good. We'll be in recess till 9:30.
Move to adjourn.
Move to adjourn public comment.
Oh, wait, I'm sorry. I am sorry. Pursuant to NRS 241, the Nevada's open meeting law. Our final agenda item before adjourning is take public comment. We're welcoming any comment by the public on any matter within our jurisdiction. We cannot take action on that. Is there any member of the public who wishes to address us in Las Vegas? Is there any member of the public remotely participating who wants to? Thank you. Now I'll accept the motion to adjourn for the day.
Move to adjourn.
Second, Jen.
And see you tomorrow is a perfectly acceptable.